Yeah. Breaking news or whatever. They're on another one. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5 goons, same deranged obsession. This changes everything. Bro, it's page 47 of emotion they skin while yeah. Breaking news or whatever. They're on another one. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5.
And I'm muted, of course. Wouldn't you know it? God bless. Good evening, everybody. I know it's running a little bit funky tonight. It's crazy as all get out, and I hope it starts streaming over on the YouTube. We'll find out here shortly if it is or not. Oh man. Let's see, is it working or not? Yeah, I know you can't hear me. We'll find out if it's actually playing on the YouTubes. It is. It is. It is. Good. 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 That's what I was curious, because for whatever reason, it's acting really screwy. Uh, like normally it would play the video, but it didn't even do that for me. So I don't know what's going on. We'll figure it out eventually. It's good to see all you fine folks tonight. Are you ready for some fun? I've got something cool for you tonight. I really do hope that you enjoy what I've got for you. Mm, mm. And see, now I'm concerned that it's not gonna work, because if everything else is acting funky, then it might be acting funky too. Good to see you all, you wonderful YouTubers, and all you that are over on the Rumble side. Oh my, oh my. We'll see if any of this stuff works. It'll take a little bit here for it to all catch up. I got 3 of you fine folks over on Rumble. Welcome, welcome, Rumblers. It's good. It's good. It's good. It's good. Yeah, good evening. How you doing, Colleen? Hello, hello, hello. Yes, yes, yes. We also missed you yesterday. Yeah, yesterday was really bad. I had a splitting headache, and it just I couldn't focus. I couldn't think straight. So it was I was asleep before 10 o'clock last night. It was bad. But we had a lot of storms roll through, and usually whenever when everything goes haywire like that, that's usually what it means, is the barometric pressure dropped. Thank you, Hats. I got it. I got it. Gwen the Ferret, Miss Peanut, good to see you. Stacy, Mary Boyle, Jen Hale. Let's see, am I missing it? I'm missing tons of people. Alan Schaefer, Florida Flipper, Diana Pisker. Well, good to see you, Diana. I'm never going to be able to say all these names right. Tammy Bugard, good to see you. Good to see you. And if I missed anybody, I do apologize. Heather May, I see you there too. Mr. Coop, hey, 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 how are you? Crazy, crazy stuff happening. Crazy stuff happening. If it isn't one thing, it's another. But I've got a song that I've been working on. I think you guys might just like it. We'll have to give it a try and see what you guys think. Let me see if I can share that, and then we'll see if it'll actually work like it's supposed to. No guarantees. No guarantees on anything tonight. Sometimes it works, sometimes it doesn't. We'll just have to find out if tonight's the night that it's going to work, or if it's not. Because I never know. I never know. But we'll give it a try and bring this up, and let's see, why am I not Add to stage. All right, there we go. And then we just do this number, and there we go. Oh yeah, I got it. Yeah, let's see if I can stretch that out any further. Well, this one is a really fun one, and I hope you do enjoy it. This is the very coolest one. Let me see if I can split that down like this, and then do this number. Yeah, there we go. That'll be a little bit better. I think you guys are gonna like this. Here we go. Check this out. This is fun. It's called You're Immortal.
I wanted to say something to all of you Stalker fans. I am sick and tired of you tormenting me, lying about me, ruining my reputation and trying to cause so much pain and heartache for me for no reason whatsoever. I shared a video of another rescue to show what a wonderful job that he does. You're evil, you're disgusting, and you're evil, you're immortal. Stop, fans, you make me sick. Woo! He's a wonderful person. He has a great rescue and helps thousands of animals. And what happened? You attacked me on that video. You accused me of stealing his content when it said right on the video that I was sharing it in support. Yeah. You're evil, you're disgusting, and you're evil, you're immortal, and you should be ashamed of yourselves. Yeah. Rescues should support each other. Rescues should learn from each other. I am so disgusted by you. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. You make me sick. But no worries, you're not gonna hurt me. You're not gonna hurt my child, and you're not gonna destroy what I started for my little girl because of someone who has stalked me and destroyed my life for 4 years for content on YouTube so they can get rich. To those of you that do care about my rescue, to those of you who do support us, thank you and God bless. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. And by the way, I'm not monetized, so why would I steal his content, idiots? I took down his video, not Facebook, so that you didn't cause any more drama on his channel. I've never caused him any drama at all, ever. I respect what he does with all my heart, as I did the same thing all my life. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. And shout out to Wildlife Rehabilitation Outpost. You do amazing work, and you should be very proud of yourself for you and your crew. Thanks for what you do. And shout out to you, evil. You disgusting. You evil. You immortal. Stop the fans. You make me sick.
Oh, I love it. I love it. I love it. I thought you guys would like that one. Did I hear about Clark Stark? No, I haven't heard about Clark Stark. I hope he's he pushed the red button. If you understand, you understand. Hello, Mac. Good to see you. Tommy, Max, good to see you. Tracy, Spencer, Murray Boyle, Colleen, and if I missed anybody, Max, hello, how are you? Bayou King, 1960, Octopus, Raven Finger, Red #1 Finger. Awesome, 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 awesome. We are on fire tonight. Get a fire hose, put me out, make me feel nice and cooled off. Early Mug Raid, welcome, Early Mug Raid. Good to see you. Good to see you. It's crazy. It's crazy. Yeah, we'll see if we have Clark had a bad heart attack. Ooh. No, I didn't hear about that. That's no good. That's no good. The real Stark Clark. Man. Oh, I hate hearing that. I don't know who Clark is. Clark Stark is a private detective, a videographer, a way in and a way out. Welcome to Mug Raiders. Please hit that thumbs up on your way in. We appreciate you. Yes, we are streaming this using the Rumble Studio. Also, we're over on Rumble. If you're not a member over there, it doesn't cost anything. You can join me up on Rumble. I'm trying the Rumble Studio out to see how well it works. I'll probably be reaching out to one of those guys whenever I have some free time. My problem is I work all day long, so I don't have time throughout the day to ask the questions that I need to ask. But I'll have to reach out to them and try to get a few things sorted out. A few things that I just am not able to do with the Rumble Studio that I wish I could do. And I'll have to address those with Rumble Studio or with Rumble at some point in time and see if I can't figure out how to make it work or how to get it done. Some of those little issues are crazy. The thing is with Rumble Studio, I don't have any way of showing the super tips, but there is still super tips available. I just won't be able to pull them up right now because I don't have that set up. That's another thing that I need to ask them for. But if you do want to support the channel, there is other ways of doing it. One of those would be you can check out my sponsors. That's one of the ways you can do it. Or another way that you can do it is we also have a nice little ticker that's somewhere here. As soon as I figure out where it is, I'll show it. I'm still figuring out how to work this whole thing. And it is somewhere in here. Let me see where it is. I think there's there it is. Yes, there's that right there. So if you want to support, you can also do Cash App. If you're not on Rumble and you don't want a super tip, you can always do a Cash App. I do have that open 24/7. I will respond to anything. Usually I'll just give you a nice little heart or a thumbs up on that. But if you do it while I'm live, I will respond to you there also. It's one way to get the full amount. Another thing that'll happen is I do have super tips, but if you're sending in super tips to that link, the only problem with it is I don't have it set up right now to actually pull up super tips. It would require me opening up OBS, running through that, and I'm usually running about 10 or 15 different tabs. Maybe if I got a new monitor. Yeah, maybe I'll just get another monitor at some point in time so that way I can just have that up where I don't because I'm usually working between two monitors right now. So once I get that all straightened out, we'll take care of it. And is it your birthday? Happy birthday, Anita. Man, we love it whenever birthdays come around. It is a beautiful thing to have the birthdays. And I think we do have a birthday song here. Let me see if I can find it. I don't know which one it is. Doggone it. I know that I've got one here. It is it this one? I think it's this one. I don't know. No, that can't be it. Maybe it is. We'll see. Nope, that's not it. That's not the birthday one. Is it it? Nope, that's not that one. Is it this one? Nope, not that one either. I don't have the birthday thing on this one. Doggone it. I'll have to get that one loaded up, but I'll just sing you a quick happy birthday. Happy birthday to you. Happy birthday to you. Have a wonderful and joyous happy birthday. And if you catch me whenever I get this rolled up in here and remind me, I will wish you a much happier birthday and show you a video. I just don't have that currently on here. Still behind the ball on that. I'll see if I can find it. If I've got it here, I will look under this and see if I can find it. Ah, yeah, there it is. I think this is it. And this might be the wrong one, but we're gonna find out. We'll find out if this is the actual one or not, because it may not be. Let's see, and we do not want to loop it, and it'll take a second for it to load up in here, and once it installs, we'll find out. Yeah, this is going to be the correct one. So we do have the happy birthday song for you. Let's see. I do believe it's this one here. Nope, it's not. Damn it. Which one? Ah, that's an overlay. Huh. Did it not save? Because I got this one, but that's not the one I'm looking for. Why is it not? Did it not? Huh. Happy birthday right there. We'll hit open. Add new media. I don't want to loop it. I just want it to play. Why is it not working? Well, we'll just stop there. I know how to do this. This will be easy. It'll be easier doing it this way. Open this up right here. And this way I can share the happy birthday with you. Give me just a second and we'll remove that. And we stop that one. We'll just do I don't know if this is going to work, but we're going to give it a try. We're definitely going to give it a try to see if this one works. Here we go. Woo! Happy birthday. Happy birthday. Kilo margaritas, party through the night. To the one we love the most. No sound. No sound. See, that's really sucks. That really sucks. Start. It should have sound. Oh, I see why. Yeah, there we go. This will have it. This will have it here. Yeah, now I've got it. Now I've got it. Got it.
Joyful time, it's your special day. Gather round, we're here to say happy birthday, happy birthday. You're the shining star, let's celebrate you no matter where we are. Tequila and margaritas,
Still no sound?
Through the night, cake and candles, the mood is just right. And the candles flicker, make a loving toast to the one we adore the most.
Happy birthday
All right. I think I figured it out. There it is now. So you got it. You got it. Happy birthday. Happy birthday to you. I'm glad that you're having a wonderful, wonderful birthday, and may you have many, many more. Cheers to you. Cheers to you. Good Lord Almighty. All right. So, of course, you know, Paint Chips has filed another bloated motion, as he likes to do, because, well, he just can't seem to help himself. And whenever he does, we usually ignore it because it's garbage. But tonight we're going to have a little bit of fun with it. We're going to read it. We're going to enjoy it. Maybe. We'll see. We'll see if it's even enjoyable. And I think I can move that right there, so we can resize the chat right there for you guys. You can still see it there. Hello, K Matt. Good to see you, Mr. Coop. He's such a dumbass. Yeah. So Paint Chip, he's appearing pro se, and especially hereby provides formal notice he doesn't consent to the exercise of jurisdiction by a magistrate judge for all proceedings in this action, including a trial and entry of final judgment. Doesn't matter. It doesn't matter if you like it or not, Paint Chip. You're in the shit. You're in the shit. Defendant expressly withholds consent to any expansion. There is no expansion, Paint Chip. It's his appointed duty to do this. Beyond this, permitted under 28 U.S.C. 636B, while they recognize that their role in handling appropriate pretrial matters, issuing reports and recommendations, insist that any dispositive rulings, including motions affecting jurisdiction, dismissal, or final adjudication, be made by an Article III district judge. Well, you can demand all you want to, but if the judge appoints him to make those decisions, well, this is the only thing that's, well, one, keeping you in the case, and two, keeping anybody else in the case. So it doesn't matter what you think, or getting kicked out of the case. But it's just more shit by Paint Chip to clog up the docket. Well, and of course, he's saying this notice is filed to make defendant's motion unmistakably clear and to prevent any implication of consent by silence, inaction, or procedural default. Well, you already defaulted once. So, I mean, what's wrong with defaulting a few more times? Under a limited or a special appearance and actively contesting threshold issues, including but not limited to service, personal jurisdiction, and legal sufficiency of the claims. Those issues to go to the court's authority. Well, the court already gave the magistrate judge the authorities, so you can just F off. That's how it works. Whether you like it or not, the judge is going to tell you, oh no, sorry, son, you just shit out of luck. No, nothing in this notice constitutes a waiver or any defense. Yeah, that constitutes you already waived your right into it, and the judge found you lacking. That's what the judge found. You were lacking, Paint Chip. You were lacking so much that the judge had to laugh off your stupid garbage yet again. And he probably will. He'll probably look at Paint Chip's filing and go, oh, great, another one of these. Oh, another one of these. And of course, he's going to ramble on in his next filing, which, you know, is a 22-page pile of absolute garbage right here. Now, Paint Chip's special appearance motion. Oh, well, special appearance. No, that's not how it works in the state of Florida, but you try that one because you already are part of it. Non-lawyer, expressly unskilled in the science of law. You should just left it there, just unskilled, like untalented, complete hack. Probably, you know, it shows you how low the bar is to actually become a lawyer. Then when they appear pro se, especially not in, and of course he's going to ramble on about this stuff. Learned in law requires present function, capacity, exercise, legal judgment, reasoning, not merely historical credentials. So doesn't matter. Doesn't matter. You're still an idiot. Submission to the court's authority, but direct challenge to it. This is not a general appearance. This is a compelled intervention. Compelled. You're not compelled to do anything unless you want to be compelled. I mean, it's more like a propeller. If you understand what that means, you're sort of like a more like an impeller. You are in Florida. This is not a general appearance. Oh, and without jurisdiction, without adherence to the most basic requirements of due process. Without jurisdiction, without adherence to the most basic requirements of due process. Well, they've never been properly brought within the court's power to rule under Rule 4. Yet funds of self-named previously defaulted, admonished that things will not end well, then pursued through a chain of errors, omission, legal shortcuts that would not survive first-year civil procedure scrutiny. Well, I don't think you could either. It seems to me that you're losing on this one, aren't you? Yeah, I don't think the judge is going to fall for your shit. That's what I think. Special appearance, sovereign citizen. No, he's trying to avoid having to be brought forth into court. This is his first step, and I can tell you that this is the same game that he's playing on Novasharian. All right. And the best way to show you is he already admitted that he's a complete artard in Novasharian's case. Not only artarded, but gay. He can't help it. He's showing that he's got, this kind of issue where he wants to be, he wants to be fighting, but he doesn't want to, he doesn't like it whenever the punches come back at him. And that's what's happening. He's out there with his little plastic sword, swinging it around, giving himself just a little bit of love. It looks a little bit like this, just dancing around, saying, "Ooh, ooh, ooh, yeah, come get me, daddy." That's what he's saying. That's all it is. He just feels all stupid. Watching on Rumble, chatting on the tubes. Evening, Shizzy and Jack. Good to see you, Wes. Wonderful. I cannot find the block in privacy in here, so giving up and cannot unblock anyone I may have by mistake. Well, hopefully you didn't block anybody by mistake, and if you did, they'll say something. Paint chips, you shy typing idiot, brain lacking fool. Thank you, Marama. That sounds about right. Defendant appears now for one purpose only. Only one purpose. I don't think that's his only purpose. It seems like it would be, but usually it's not. He's got another agenda. He can't help it. And to expose the jurisdictional void, to prevent further reliance on defective process, insists that this litigation proceed, if at all, within the bounds of federal rules and the Constitution. Well, that's not for you to decide. That is for the judge. See, you're not the judge. The judge will rule on this, while you are getting your ass handed to you for making revenge porn on the interwebs. That's why you got in so much trouble in the first place, wasn't it? Isn't that why your buddy Volmit got his channel removed for making internet porn and posting it online, or was it all the other bullshit that he's been removed for on the YouTubes? Yeah, didn't he get removed because he decided to mess with the wrong people? Yeah, like the YouTubes, they don't appreciate you. They don't appreciate you, Paint Chip. Isn't that why you evaded the ban? Got yourself a new channel, or is it because old maybe helping old Crook write his filings because Deuce got into so much trouble for it in the first place? So are you trying to write those for him too? I wouldn't be surprised. Defendant appears now for one purpose only: to expose the jurisdictional void, rub a hard one out, and to prevent further reliance on defective process, to insist that this litigation proceed, if at all, within the bounds of the federal rules and the Constitution. He does so with expressly preserving every defense under the federal rules of civil procedure 12, including lack of personal jurisdiction, too late; insufficient service of process, too late; lack of subject matter jurisdiction, too late; and failure to state a claim, too late. It's already too late. You defaulted already. Whenever you were supposed to answer, you didn't, and you did so by being a douchebag. Accordingly, and without waiving any rights, defending hereby moves for the following relief: clarification and reconsideration of their 23rd order pursuant to Federal Rules of Civil Procedure 54B to address whether the order was entered prior to the expiration of defense's response period under Local Rule 7.1E. No, or else the judge wouldn't have ruled on it. See, the judge ruled on it, and guess what? He gave you plenty of time to file a response. The rest of this is all just bullshit, and it wouldn't surprise me with your garbage. And also, you're one of the people that were emailing the judge, and they didn't really appreciate that. That they don't just kick this shit to the curb and say, yeah, time to move on to the next one. He also wants leave Nuck to file full merits process and Rule 12 motion, where defendant's prior filing was directed from conferral deficiencies and not intended as a substantive opposition. And then, of course, he wants to attach Exhibit A. Judge Weinstein also concluded that this case illustrates the danger in ignoring mental health problems of practicing lawyers. Does not matter. You're not a practicing lawyer. He cannot possibly be treated as a lawyer capable of rendering sound legal advice to others, much less himself in a federal case where he appears pro se, judgment proof, mentally impaired, and without counsel. And did you put in there that you're also gay and retarded? I'm just curious if you put that in there. You should have included that in there. The judge probably would have appreciated that, because, hey, judge might be gay and retarded too. I don't know. You probably could be gay and retarded together if you wanted to be. That would be entirely up to you. I mean, I've got no say so in that. Though he's bringing up his old felony. Oh yeah, he's bringing up his old felony, and it's just hilarious. I doubt he gets all of it in. And I think it's just his removal from the bar. That's all that it is. And basically what they were saying in that, and at some point we can read through it. I think he filed it with this. But according to his filing, that he's a pretty dangerous individual. I'm sure he left out the part where that, he likes to cause litigation. If memory serves, didn't Paint Chip send some not so flattering Photoshop pictures of the judge to the court? Well, he might have, but that was his reason for doing it. So that way he could say the judge is prejudicial to him because he was mocking the judge. This might be a hot take, but Paint Chip might be worse than Deuce. Well, there's a possibility. It's cool that he goes and gave the court the old case so they know not to trust this guy's judgment to do a past criminal behavior. Oh, there's much more. No, his only judgment that he's showing is his ruling for being disbarred. That's all he's showing. He's not showing the rest of it. He's not showing, he's not showing, where he cried. He cried on the gay report or something like that, because he didn't want to get any more love from Bubba in prison over and over and over again. That it hurt his little fifis, that they treated him like a meat puppet. That's what he was saying. He cried and cried and cried his little head into the pillow, buried it down, wept. And without counsel, an order permitting prompt Rule 12 briefing on threshold defenses, including insufficient service of process. That's already been taken care of. You've been lack of personal jurisdiction. That's already been handled. And failure to state a claim. That's already been handled. Alternatively, reconsideration of leave to amend as to defend on the grounds that service and jurisdiction remain unresolved and the proposed third amendment complaint is futile as a matter of law. No, the judge already ruled on it. What the judge said is that you have a certain amount of time from the date that was filed to file a response. Right? I mean, I'm pretty sure that's what the judge said. I mean, I could be wrong on that. Let me double check, but let me see if I have that particular one up here, because I'm pretty sure that that's what it said, and I'll double check. Let's see, 180. I think this is it. Let me double check. Oh no, that was him to leave to file a second amended complaint. Let me see. I think I have it. Here, let me see if I've got it. I'll double check. And it was, let's see, is this it? No, that's not it. Let's see, 186. Oh yeah, there it is. Let me see. It was the judge's order, came in. But all proceedings, okay. Just want to double check. Oh yeah, it's already been filed. Yeah, that's pretty straightforward. I wanted to double check because I knew it was here. So it is so ordered, the motion ECF number 182 for leave to file the third amended complaint is granted. The third amended complaint is deemed filed as of April 23rd, 2026. The clerk must enter a judgment stating, based on federal rule of civil procedure, all claims against defendant, Cook, Deuce, all the other ones, we just won't go all through, name them, are dismissed with prejudice. Helm's motion for the judgment on the pleadings is denied as moot. The claims against Preston and Paintship remain pending, but all proceedings against Preston are stayed. The court retains jurisdiction to award attorney's fees and costs on timely application. The case is remanded to the magistrate judge for further proceedings. Oh, yeah, that was the Judge Hinkle. Maybe you should have read that. Judge Hinkle filed that. But what can you say? More than likely, he said, I guess, that's you're sort of sucking. Yeah. So you're sort of stuck right there. Judge Hinkle said, hey, it's remanded to the magistrate judge for further proceedings. And well, if you're arguing with the magistrate judge, looks like you're arguing with the district judge, and he's gonna have a hard time saying it, much of anything right there. And it says, you've got now Paintship, you responded in 185, inappropriately attached an email opposing counsel rather than simply filing a response with the court. And it granted a leave to file a third amended complaint because of bankruptcy proceedings and Miss Preston's estate. When the third amended complaint can probably be filed against her may be unclear, but the litigation can properly go forward against the other defendant, leaving the second amendment complaint pleaded against while proceeding on a third amended complaint against the other defendant would undermine rather than serve the purposes of bankruptcy stay. Now, as set out on this, second amendment complaint fails to state a claim to the defendant. The deadline for further amended complaint for those defendants passed. No reason to keep them in litigation, and he removed the other ones. But you've got a certain amount of time to respond there, son. You may want to actually respond to the complaint, because you've already been defaulted, had moved to vacate the default, and had not moved to dismiss at that time, and those have been stayed. Yeah, so it's you defaulted already. Yeah, that's what it looks like right here. Maybe you should have read that there, son. Doesn't seem like you read it. But hey, that happens to you. That happens to you, Stupid hits you whenever you least expect it. Yours hits more often than everybody else's, but hey. The proposed third amendment complaint is futile as a matter of law. Search further relief, ensure defendant meaningful opportunity to be heard, and he wants to mitigate this and other relief the court deems just and proper. And of course, he has to make a statement here, complain about this motion. It's not a general appearance. Yeah, no, it's too late. You you're not an attorney, so it really wouldn't be any sort of appearance at all. It would just be you, joining in and coming in. Yes. Hold on just a second. I'm typing in something. I hate this because my fingers are so big. There we go. The procedural posture matters. The court has already made it clear the case that parties are not to communicate informally with chambers. Well, how did they make it clear? They made it very clear because you were emailing the freaking judge and wasting their time. So if you're going to file something, you're going to have to file something through the proper channels, which means you don't have to have all the fluff that you like to put in there. The bloviating of bullshit that you have to spew every time that you're involved in a court case. There's a little term that I learned in the music business. It's called keep it simple, stupid. If you can't keep it simple, it just shows that you were that bad of an attorney. And you can also tell whenever somebody has to file long filings over something so simple and minor that they just like to hear themselves talk, that they really don't have anything else to say. And they're usually wrong. They're usually wrong in it. Whenever it's this overinflated, manifesto of sorts, it usually means that they're trying to baffle you with bullshit. Now, the court already made it clear in this case that the parties are not to communicate with chambers. Local rules separately provide that requests for court action must be made by filing a motion or filing. Yeah, by letters or emails to the judge. After prior informal communications, the court warns the parties can do that. So you have to repeat what the judge told you? Is that what it is? Because, let me get this straight. Maybe I don't understand. The length is only to put sleep does not reading has no meaning other than losing the meaning and not answering the request for respecting the order. Yeah. Defendant did what the local rules required. No. He filed a notice of filing to place the conferral effect and related correspondence on the docket, preserve the issue, and create a reviewable record. But see, that's where the judge was like, yeah, you're wasting the court's time with resources that we're not playing this game. He said, you file a meaningful motion. We know that you don't do much of anything that's meaningful. I mean, I guess you help, give a little bit of that carbon dioxide to the trees, but other than that, not really much of anything. That filing was not merits-based brief. It was not anything. It was absolute trash, and that's why the judge said no. The notice itself states the defendant filed it specifically without waiving jurisdictional service, and maybe that's the point. The judge is not going to have you file a whole bunch of shit in his court. I mean, if that's what you're going to file, the judge will probably just kick it out and say, yep, you defaulted, asshole. Why don't you file a meaningful brief? Something that's meaningful. Because none of this, all this other garbage that you're doing is meaningless. The problem is that the problem is you keep filing dumb shit, stupid. That's the problem. The more you file dumb shit, the more the judge is just going to be like, yeah, you're wasting my time and the court's time. They better give as much time as they have on these idiots. I don't think Jeremy pays too much attention to these idiots. That's why he hires an attorney to do it. The only time that he responds is whenever he feels like there's something that he needs to respond to. Other than that, this is all just garbage. It really is. Filing of telling what he did during the day would have more meaning than whatever we're reading here. Yes, absolutely. Absolutely. Now, he's inappropriately attaching an email to opposing counsel rather than simply filing a response with the court, then granted leave to file a Third Amendment complaint. Respectfully, clarification is required. No, you're the most disrespectful piece of shit out there. So I don't think the court should even bother wasting their time with your respectfully. Yeah, okay. And then granted leave to file the Third Amendment complaint. Defendant was attempting to comply with the court's prior command not to email chambers by using a formal docket to bring the local rule. That's not what they wanted. Well, if they intended, well, see, now here's the problem. You're assuming again, paint chip, and that's the problem. Who is DAC? What did he do? I don't know who's DAC. DAC never even called me by my name. Big country music singer once upon a time. Oh, okay. Rather than respectfully clarification is required, the defendant was attempting to comply. No, you weren't. By filing bullshit in the court, that's what he's trying to say is, oh, I was filing bullshit with you, judge, in the court to waste some more valuable time because you told me not to email, court chambers with bullshit anymore. So I'm gonna clog up the docket with more bullshit where the judge also said, how about not filing anything except substantive filings? But that wasn't a substantive filing because there was no reason for it to be there. I guess the best way to compare it is, you're in a clean room, if you know what a clean room is, ever worked on computers, you're in a clean room and then somebody brings in like a floppy disk, or a USB drive and then says, well, I didn't plug it into the computer. Yeah, just having it here is going to cause a problem. Because all it takes is one person to plug it in, and then you'll spread whatever virus we're trying to keep it fine with. Defendant respectfully submits to such treatment would convert a procedural preservation filing into a forfeiture trap. And that's not what defendant filed. No, you filed garbage, absolute shit. And it's not what the federal rules require. Well, why don't you go back to school? Why don't you go back to school? Go get your law degree. Oh, that's right. You can't get a law degree. So how would you know what the federal rules require? See, the problem is Paint Chip just wants to argue. And that's the same way with Volmet and Ducey and the Flea and all these other people. Instead of filing something that's worthy of, being filed, it's just they're filing shit just to stir up more drama, so they can get those clicks, so they can get the views, so they can get people paying attention to them because their lives are so meaninglessly boring. They're just clawing at relevancy. That's so bad. The timing confirms the problem. No, the problem is you don't know about the law as much as you thought you did. You want to be shady and do shady shit. He couldn't print a fake one from some random website and pretend it's real. No, that's how do nuts do anything. What? Yeah. Defendant's notice was filed to preserve the conferral issue, not brief futility. No, it was all futility. Everything that you're doing is futility. First Amendment defense is a pro se defendant who obeys the court's instruction not to email changers should not lose his opportunity to be heard. Be heard. No, there's a time and a place for it. And that's not the time nor the place. See, if you want to be heard, then you choose the time and place. And, well, this is not the time nor the place. And the judge is going to say, nope. He does not ask the court to hold that Rule 7B has been erased from the case. Well, that's what you're saying. That's what you're trying to accuse the court of. Well, nor does the defendant ask the court to turn every future motion to mere notice of intent to file exercise. Well, but see, that's the thing, is that the judge already ruled on how he wanted you to respond. And it's too bad that you couldn't read what he said. Follow the local rules. Would have been a little bit more simple. The clear point is narrow. If plaintiff's April 14th email was deemed sufficient for purpose of the motion for leave, the court should clarify whether that was a one-time exercise of discretion. No, they don't have to. You know the rules so much, why don't you fucking read them? But apparently you can't even follow those simple rules. The judge told you what to do. Hello, oops, you're bad. At Valley News Parody. Multi-aliasing is not my superpower. The clear point is narrower. If plaintiff's 14th email was deemed sufficient for purpose of the motion for leave, the court should clarify whether that was a one-time exercise of discretion or reciprocal case management rule. No, it's not a case management rule. It's what the judge told you to do. If the judge rules and judge tells you to do something, that's what you do. You appear lockstep, but you're an idiot, so I don't expect that to happen. Court should clarify whether that was a one-time exercise of discretion or reciprocal case management rule. Defendant's forthcoming Rule 12 motion does not require conferral anyway, if it would determine the outcome of a claim. Stop being stupid. 7D exempts dispositive motions from the conference of certificate requirement. See, now here's your problem, stupid. Here's your problem. See, you're throwing all this stuff out there, which means that the judge has to take its time to look it up. If he doesn't know it off the top of his head, and he'll look at it, and it's taking up more time and resources. So more than likely, after he reads through your bullshit and he's looked all that up and he's spent who knows how long actually looking at the exact wording of it, he's gonna be really pissed off. So maybe you should have cited it in there. But of course, you're an idiot, and this is the way that they do things. I don't know, where is it that you're from again? Some one of them Yankee towns somewhere up there. That's fine. I'm just pretty sure that they do things a little bit differently in Florida. I don't think they also appreciate posting revenge porn on the internet. But hey, that's just me. I don't think they like that where you're from either. Defendants anticipated Rule 12 motion, rising lack of service. No, there was no lack of service. There was no lack of personal jurisdiction. There was no lack of subject matter jurisdiction. And there was not a failure to state a claim. It's dispositive is to the only claim asserted against them. No. The threshold jurisdictional issue remains live. Granting leave to amend did not decide whether the defendant had been validly served or whether this court had personal jurisdiction over him. Rule 4 is not a technical ornament. Well, you're not the judge. Dim the lights. Cold flannel and pillow for you. Dim the lights. Oh, sounds like we're getting sweaty. Those objections should be briefed before the defendant is required to litigate the merits of a newly filed, whatever we're going to babble on about here. Newly filed pleading. The amendment is also as futile as count 2. The only claim now is asserted against Paintchip. Well, how is it? How is it futile? I don't think it is. I think it was pretty straightforward. Pretty sure it was. But what can I say? That you're an idiot. Oh my God. But the third amended complaint does not plausibly allege the statutory core, a real private. No, it doesn't. No, that it doesn't matter. See, you filed what is considered revenge porn. You posted it. You can call it satire, you can call it anything you want to. There's certain things that you're not allowed to do. And that would be one of them. You might want to actually read what the statute is that they cited. Matter of fact, why don't we pull up the statute that was cited, not from what he cited, but maybe we look at what actually was cited by Randall Shockett here. I'm pretty sure that we'll find it in here. Let me scroll down here and let's see here. We will find it really quick. And well, internet address and let's look at count 2. Well, no, that's D. That's stalking. That's the video. That's count 1, malicious prosecution. Count 2. All right. Why don't we just look up right here and we'll see what that is, and we'll find it here on the interwebs, because it's much easier to do that. And Florida statute 749. And let's see. 784. And I'm pulling it up right now just because I'm actually interested in what this has to say. 74049. 784. And down to 74049. 78. So okay. All right, let's remove that and we'll share this screen right here so we can look at it together. So maybe it makes a little more sense. There it is right there. It finds that a person depicted in a sexually explicit image taken with the person's consent may retain a reasonable expectation that the image will remain private despite sharing the image with another person. It's becoming common practice for persons to publish sexually explicit image of another to internet website or disseminate such image through electronic means without depicted person's consent, contrary to the depicted person's reasonable expectation of privacy. When such images are published on websites, the images are able to be viewed indefinitely by persons worldwide and are able to be easily reproduced and shared. The publication or dissemination of such images through the use of internet websites, electronic means creates a permanent record for the depicted persons. It's just giving you what their findings are. Now, safeguarding the psychological, 2 is used in term image, not limited to any photograph, picture, motion picture, film, video, or representation. Notice right there, or representation to any photograph, picture, motion picture, film, video, or representation. Okay. Personal identification information means any information that identifies a person and includes but not limited to any name, postal, electronic email, phone number, social security number, date of birth, or any unique physical representation. And that would where it would fall, unique physical representation. Sexually cyber harass means to intentionally publish to an internet website or intentionally disseminate through electronic means to another person a sexually explicit image of a person without the depicted person's consent and contrary to the depicted person's reasonable expectation, the image would remain private if it conveys the personal identification information of the depicted person, which it does. The personal identification information of the depicted person is not contained or conveyed in the image itself, but is contemporaneously published or disseminated in such a manner that a person viewing the personal identification information would reasonably know that such information directly relates to the person depicted in the sexually explicit image. What it says here is evidence that the depicted person's image sent to another person does not on its own remove his or her reasonable expectation of privacy for that image. The image means any image depicting nudity as defined in 84.7, depict a person engaging in sexual conduct as defined in 84.01, or depicting the display of a seminal or vaginal secretion on a person. So right here, as defined in 87041. Let's open that up in a new tab and we'll look and see what that one is right there. Da, 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 da. Ah. Oh, right here. Let's share this tab right here. And in case you're curious, what I'm looking up is if there's talking about a deviated sexual intercourse means sexual conduct between persons not married to each other, consisting of contact between the penis and anus, the mouth, the penis, or the mouth and the vulva. Harmful to minors. Masochism. This is what I believe it means. Gratification through torture or humiliation. Obscene means the status of material. An average person applying contemporary community standards would find, takes as appeals, depicts or describes the patently offensive way sexual conduct as specifically defined herein, or is taken as whole, lacks serious literally, artistic, political, or scientific value. And it does none of that. Mother breastfeeding, promote means to promote, sadism, sadomasochism, sexual excitement means condition of human male when a state blah, 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 stimulated, and basically just goes down through all of what these things are covered. Female breast below the top of the areola, human male genitalia, all that kind of stuff. Sexually oriented material right there. Makes sense? Depicting this display. So if a person as engaged in sexual conduct is what it's talking about. That's what it's talking about. Which they did that. Except as provided in subsection B, for a person willfully, maliciously, sexually cyber harasses another person, commits a misdemeanor of the first degree, is punishable and is provided in 75. Person who has one prior conviction of sexual cyber harassment and commits a second one commits a felony in the third degree, punishable as provided. Except as in provided paragraph, the person who violates this section for the purpose of pecuniary or any other financial gain commits felony of the third degree, punishable by a felony. Second degree. And if they do it again, it becomes a felony in the second degree. The purpose of this section is to term conviction, blah, blah, blah. Law enforcement officer may arrest without warrant any person that he or she has probable cause to believe has violated this section. So they could actually have him arrested for it. An aggrieved person may initiate a civil action against a person who violates this section to obtain all appropriate relief in order to prevent or remedy a violation of the section, including the following: injunctive relief, monetary damages to include $10,000 or actual damages incurred as a result of a violation of this section, whichever is greater. Punitive damages, reasonable attorney fees and costs, criminal and civil penalties this section do not apply to. A provider of an interactive computer service, information or communication services that provide transmission, storage, caching of electronic communication, messages of others. So basically you can go after YouTube for it. So you would have to go after the person. Law enforcement officer, any state or local military that publishes or disseminates a sexually explicit image in connection with a performance or his or her duties won't have any problem with it. A violation of the section is committed within the state if any conduct of that is an element of an offense or harm to the depicted person resulting from the offense occurs within the state. So I think we covered all of that right there. Every single bit of it was covered there, Paint Chip. So whenever you're over here rambling about your shite, which we all know is bullshit anyway, you lose miserably on that, son. And it looks like, all of this is because he's trying to say that it's satire and mockery, but it's clearly not. It is clearly not satire. It is clearly not what he's trying to intend it to be. Commentary on controversy cannot be transformed, but that's not what it is. And they give very, very, very solid rules around that in the state of Florida. Yeah. And, Falwell was a little bit different. Just saying. But go ahead and argue that and see how well that works out for you. Defendant also requests a limited procedural solicitude consistent with his pro se status. I wonder what he's a procedural solicitude. I wonder what that is supposed to mean. I've never heard this solicitude. Is that like soliciting with a bad attitude or something? I'm curious. Let's see, what in the hell is that? Okay. What he's saying is it refers to the heightened care, leniency, or special consideration to certain litigants, typically pro se, to ensure they are not unfairly disadvantaged by technical legal rules. And that's something out of New York, out of the Northern District. Oh, well, and this is common in pro se litigants in the Northern District of New York. And I'm pretty sure that doesn't exist in the state of Florida. Does it exist in Florida? Let's see. Let me go back and look again. Does this exist in Florida? I love Google. It'll give you those kinds of things. Nope, it doesn't. Here, I'll show you. I'll show you exactly why it doesn't. Let's remove that and share this other screen here so you can understand what he's asking for in the state of Florida and why it doesn't matter. Right there. So as you can see, what it says here, uniform standards, technically self-represented parties are held to the same legal standards and rules of evidence as licensed attorneys. Courts will not typically suspend rules for a party just because they lack a lawyer. For instance, you're still expecting to meet all filing deadlines, such as this 20-day window to respond to a petition, mandatory FRERETA inquiry in criminal cases. Support resources include a broad procedural leniency. Florida provides structured tools to assist you, such as the Do-It-Yourself Florida program for court forms and the Pro Se Handbook for appeals. Note, if pro se filing is completely unresponsive or fails to follow basic procedure, an opposing party may still file a motion to strike to compel a proper answer. Interesting, huh? What is I guess you didn't read the rules in Florida. Like I said, you're an idiot. Yeah, that's pretty straightforward right there. The judge already explained this to you once. He expects you to follow the same rules that every other pro se litigant in the state of Florida has. If you don't like it, get yourself an attorney. If you don't want to get yourself an attorney, well, one will not be appointed to you. But alas, Paint Chips doesn't know how to read the rules yet again. So he likes to whine and cry about shit. And it is not consistent with your pro se status. The request is practical. No, it's not practical. Not in the state of Florida. Defendant asks for liberal construction of his filing. No, you don't deserve any of that. There's a little pro se handbook that you could have right there. a little pro se handbook that you could go and find all of this information if you even just simply Googled that. Now that's very interesting. Of course it is. I tried to find the interesting stuff because I had never heard of this. And I'm like, what the hell is a procedural solicitude? What? Yeah, it's not going to happen. Not in the state of Florida. Judges don't find this kind of shit amusing. They actually disregard quite a bit of that stuff because they don't have time for your garbage. Oh, that's awesome. I love it. So the request is practical, not grandiose, which it is. And of course, let me do this because, he likes to do that kind of crap. What a moron. Do this. Apply. Continue. Chip. There we go. Save. Yes. All right. Let's bring it back up. So the accommodation does not alter the federal rules. Actually, it does. It entirely goes against what the judge has ruled on because he doesn't have to grant you any leniency towards this. Sometimes judges will, but Randy can easily file a motion to have this stricken because you're required, just like every other pro se litigant, to not be a dumbass. But, we already knew you would be a dumbass from the day you were born. That accommodation, it does prejudice the plaintiff because if you grant him leniency, then Randy should expect the same leniency, which the judge hasn't given him any leniency. It simply reduces the confusion in a case where the court has already forbidden informal emails to chambers. To all parties, you fucking moron. See, he doesn't want you clogging up his life with a bunch of bullshit, which is what you would do. And you know that that's what you would do. I wonder if I could do this. I wonder if it does it. Does it? No, it doesn't. Doggone it. Oh, what was that? There's a multi-video series from Tim and Eden where they moved Eden up to Alaska from Florida. I don't know anything about that. The uploaded research memorandum correctly identifies as the strongest, safest, rule-centered path, but it's not. It's not the strongest. It's not the safest. It's absolutely worse than that. For these reasons, the defendant respectfully, you haven't ever done anything respectfully, requests clarification or reconsideration of the 23rd order to file a full merits response and Rule 12 motion, preservation of all jurisdictional and service defenses, reconsideration of leave to amend as paint chip of if the court reaches futility now, and such other relief as necessary to ensure that his case proceeds by rule, not by a procedural accident. Well, it wouldn't be a procedural accident. He would absolutely be making sure that everything was done like it was supposed to be done. Oh my gosh. The background, the case has been pared down to 2 remaining defendants. Well, we already know this, so we don't have to read through the background. Of course, let's see. Oh, no. Oh, no. See, we have to read through the background because the background is where the craziness lies, because he's misquoting the background on the case. Now the order granted Hales to file a third amendment complaint naming only Lynette and paint chip while directing entry of judgment for the other defendants. Third amendment complaint now asserts count 1 for malicious prosecution against Princeton and 2 for violation No, it would be violation. It's not alleged violation. It's violation, just the same way as with her. It would, I mean, if you read it, he just threw Lynette under the bus right here, because he's saying, well, hers was malicious prosecution and his is alleged violation of sexual cyber harassment. And it wasn't against Luthman. It was against Jeremy Hales. See, you have to understand that the violation of Florida's sexual cyber harassment statute was not against Luthman, it was against Jeremy Hales. But of course, I don't think reading is his strong suit on a lot of shit. At least that's what it appears to be to me. Just not quite there, Paint Chips. Not quite there. Now, before that order was entered, he noticed a file placing on the docket his correspondence, and that filing was, it didn't matter. The judge kicked that out. The judge said, no, it's been stricken. Now, on the 24th, defendant sent a written conferral communication to counsel, identifying in detail the motions he intended to file, including reconsideration or clarification order, dismissal for lack of personal jurisdiction, insufficient service, and dismissal for failure to state a claim. And then he wanted to go into constitute a meaningful conference. No, that's exactly what it was. He doesn't have to give you a conference. All he has to do is tell you what he intends on doing, and your answer can be simple. See, you might want to have actually read this his head is so far up in New York's ass. He's got it like as deep in there as he possibly can, because that's where he went to school. That's where he got his little buddy to take care of him over and over and over again. And maybe he just knocked all the sense out of him. That's what I'm guessing, because there's different statutes, different laws in Florida as far as the way things are handled, which is very clear, because I've seen attorneys file things in like the Northern District, and those rules don't apply in the Northern District. Matter of fact, there was something just recently that they filed in the Northern District of Florida, and the Northern District of Florida said, yeah, that doesn't apply here. Well, it's like, I don't know what you're filing, but there is no such rule for that. I mean, I'm not saying that it's not a bad rule. It's just, we don't have that. That's not one of the rules. So, you can't argue that you didn't do X, Y, or Z on a certain timeline, because, well, that's a different jurisdiction. They handle things a little bit differently there. If you knew that area of Florida, you'd understand that. Futility of amendment, the First Amendment defenses. They also requested a whole bunch of other shit. Oh, yes, they did. They requested proposed dates and times for a live conference, made it clear he was attempting to comply in good faith with the local rules while preserving all defenses, maintaining a special appearance. No, he does nothing in good faith. At least nothing that I've seen. I mean, if you guys have ever seen anything that he's done in good faith, I mean, you're welcome to correct me on that. But I'm pretty sure that I haven't seen anything that he's done in good faith. But I think it's time for a little break. You guys want a little break? We'll give you a nice little music break. How's that? Let's see if this thing will actually play. If it doesn't play, then we'll do it the old-fashioned way.
Got the big boss energy, got me feeling stupid high. If you need somebody close, I can be that kind of guy. I can carry all your stuff, I can flatter you all night. Yeah, I'll be there, I won't move, I'll say anything for you. If you want a man right here, baby, I could be that fool. I'll be your stinky Travis, pick me please. I can play the loyal man, I can laugh before you joke, I can clap before I can tell you you're the king, I can kiss your heavy hand. If you want a shadow near, I can be your biggest fan. I'll be soft, I love proof, I keep all my eyes on you. If you want a man too big, stinky, stinky, I'll be your stinky boo, stinky boo. I'll do anything you want me to. What are you waiting for? I'll be your stinky, stinky, I'll be your stinky boo, stinky. I'll be right here acting desperate too. What are you waiting for? Say the word, I'm at your feet. Call me up, I'm in the street. Tell me jump, I'll ask you how. Tell me later, tell me now. You want devotion, you want praise, you want somebody trained. You want a yes man on a leash, and baby, I'm ashamed. I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo. I'll do anything you want me to. What are you waiting for? I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo. I'll be right here acting desperate too. What are you waiting for? Stinky poo, stinky poo, stinky poo. I'll be your stinky poo. What are you waiting for?
Thank you for that. I'm just having too much fun. What? No sound. I know I muted myself. As you do whenever you're laughing really hard. Sorry. I'm not muted anymore. I'm normal. I'm not anymore. You still can't hear me. I know you can hear me now. Damn it. I'll let you guys catch up and you'll go, okay, we can hear him now. But thank you so much, Rogue Pirate, for the $2. I appreciate it. I just left it. I get blinded again. Yes. Yes, you absolutely did. Thank you. Thank you. Thank you. Oh my gosh. I appreciate it. Well, skunk flavored ice cream, here's the problem. You probably don't understand a whole lot of anything, and that's sort of your own problem, not mine. If you don't understand it, then well, maybe you'll figure it out before you file something stupid again. Good luck with that. And Rogue Pirate, what the F? I just love Megan, and I get blinded again. Thank you so much, Rogue Pirate. I appreciate that. You are a gem and a true one. I appreciate you. So he is a pro se journalist of limited means, but just enough to be dangerous. Just enough to be stupid. I'm just a pro se litigant. Stupid as can be, anybody can see. Just good Lord. Oh, so he's saying that he's burdened by substantial financial liabilities, unwilling to hire counsel. See, it's not that he's unable, he's just unwilling to hire counsel because counsel would tell him, you just need to settle this shit. Here's the thing, Paint Chips, you were told to take it down multiple times. After the first time, you probably should have listened, but I guess you didn't. That seemed like a really big problem. Skunky Poo was ignorant towards Jeff legal vices earlier in Jay's chat. He was a naughty little skunk. Hey Taz, I appreciate it. Normal, come on. We know better. Yeah, that's so true. And thank you, Taz, for the $2. That's absolutely true. We know better. The thumbnail case was created by a mad scan. Yeah, absolutely, Valor. That was another one of those things that got them all bungled up. Another one that Lynette's going to lose her ass on, and she's already going to lose her ass in. Well, let's see, bankruptcy. She's screwed there. She screwed up in the thumbnail case. She screwed up whenever she went after what she called trespassers, whenever they actually had a reason to be there to remove somebody's personal property off of somebody else's property. And then, she was just like, I want to trespass. Well, they didn't intend on coming back because they were there to get their property. But of course, this dumbass, she goes and sues on that one. That was another one of Paint Chips, or not Paint Chips, but Manskin's great ideas. I mean, he seems to be failing pretty miserably in a lot of cases. Sort of like his mac and cheese shit. This will be something that he'll be probably rambling about for quite some time. He can't help it. He can't help it at all. Oh, and of course, now Weinstein warned of dangers of created when serious mental health problems in practicing lawyers are ignored, but you're not a practicing attorney. Now, see, what happened is Weinstein, he might have warned you then, but you're not a practicing attorney, right? And if you've got serious health problems, well, then you need to go about the proper way of doing that, which means that, you'd actually have to have a doctor subpoenaed, and you'd have to, prove all of what you're saying is true. You know, the bullshit that you filed that's attached to this doesn't prove anything except at the time the behavior that you have, which is garbage. You know, it's absolute garbage, and they know that you know you're unfit to be in in you know, in normal society, because, well, you're not normal. You're a sexual deviant that has issues, serious issues. And, you know, maybe the best place for you is in jail. I don't know. Could be. Hey, Rosalind. Night Court was more legit than BBB, to be honest. Well, I mean, Deuce actually made some good points. The only problem is, you know, he just aimed him in the wrong direction. Because why do you think he left? Because he wanted to try to do things in the background. The only problem is that got him in trouble, because now he's got a UPL against him in the state of Florida, which is about 7 felony counts in the state of Florida. Or is it more? Maybe it's 14. It could possibly turn into 14 felony counts of against him in the state of Florida. And then he has to still deal with the Connecticut grievance committee, where he could possibly lose his bar in Connecticut. They've already found him guilty of unlicensed practice of law in Connecticut. And that we don't know quite yet what Massachusetts is going to do about it. But hey, you know, this is the people that they like to hook up with. This is how Lynette operates. She's getting grifted by the grifters. They're using her to make money, and they'll continue to do that. They're using her, and they're using this little Peckerwood to do the same thing. No, it's a little bit different there. The problem in Levy County is, and the reason why he's suing you, it might be the postings of those signs that you posted up. That might be the problem. Also, why your little bullshit is going to get thrown out of court. But see, that seems to be the only one crying, is little skunk butt. You know, he just can't help it. He seems to be so angered. But see, what he filed was, you know, incorrect. And well, that's going to be, I'm sure, brought up at some point in time, because we might go over that filing tomorrow. That one's going to give you a really good laugh whenever you see that one, because he's going to find out really quick how fast that judge doesn't tolerate his dumb shit, especially whenever he doesn't even file things properly. Yeah, that'll be interesting. that one's going to be fun to watch. See, the problem is these guys still don't get it. They don't understand that whenever they're posting, you know, those kinds of things on the internet, that the internet has them there forever. And that definitely, the judge is going to be moving forward with that. So yeah, they get screwed in bankruptcy. They get screwed in Fed 1. She might get out of Fed 2. Who knows at this point with whether that's going to happen or not. She definitely is getting hammered in the thumbnail case, and also getting hammered in the trespass 5 case. Well, and let's see, you know, she just all around keeps screwing up, you know. But you know, she'll listen to people like the Flea that, you know, is probably going to end up getting sued also. You know, revenge porn, all that kind of stuff. You know, the kind of things that, you know, people that don't run a business don't understand anything about. Hey, you know, what do I know? I'm just an idiot with a plastic helmet that somebody else now owns. It's beautiful. Helms makes content from litigation and money from his litigation content. That's not true. It's nice to think that, but no, that would be untrue. Now, I make money off of litigation content because that's what I do. That's what I do. I talk about litigation. Whether Jeremy wins or loses does not affect me whatsoever. If Jeremy lost absolutely every single thing suing these people, it wouldn't affect me. If he won millions of dollars, it would not affect me. None of what Jeremy's problems are affect me. I'm not tied to Jeremy, which a lot of people seem to not understand this. So I can mock the shit out of people like Skunk Butt and, mock the shit out of all these people. And that's just part of being dumbasses and doing dumb fuckery in the state of Florida. And yeah, all those FOIAs that are coming out, it's really good to know. I own the banana. I know I have my favorites. I am so glad that you own that banana. It is a wonderful thing. It's beautiful. It is absolutely beautiful. What is Rumble saying? Oh, well, thank you very much, Barbie Juarez, for follow on the Rumble side. I definitely appreciate it. Oh, that's absolutely wonderful. That was plaintiff choice by his counsel, Randall Shockett. No, oh, Jesus Christ. He's an idiot journalist. And limited means, it doesn't mean that, here's the thing. Just because you're broke does not mean that you've got a free pass to misbehave. And see, that seems to be the problem. No way he wrote that himself. That has Bruce's name all over it. Well, yeah, sort of. You doing? Oh, doggone it! Why is that doing it? I'm trying to drop. Why does it keep pulling it up? Here, I'll do it this way. We'll just do that, and then I can do that. Okay, it just kept pulling it back up. I'll get this thing figured out eventually. Now, Jeremy Hales nevertheless chose to drag him into federal court on a legally defective. No, it's not legally defective. It's actually strikes pretty right on the money. Aimed at political satire. But, well, one thing, Jeremy is not a politician. So, well, that can't be political satire. Press commentary. Well, just because you have the ability to say certain things doesn't mean that you are free from liability of being sued. And public expression, but only if it's political. See, there's certain things that are called defamation, and that sexual cyber harassment, which single thing that he did falls within the bounds of that cyber sexual harassment. So that's what is going to what's going to happen to him. He's going to be, and there's a big possibility that he might get hit with a lot more than just that. Just depends. And it was plaintiff's choice and his counsel, Randall Shockett, co-signed. Well, actually, Randy filed the pleading, and it would be Jeremy's name all over it, not Randy's. Well, Hales makes content from litigation and money from litigation from his content, and Paint Chip has now decided to make content from the exposure. Monkey see, monkey do. That's the only problem is, we've seen your kind of exposure, and it's pretty disgusting, Paint Chip. I would say it's pretty disgusting. I'm pretty positive. Then I have a song for that one. I think we, never mind. I'll play that one later. Then he cannot complain when the defendant he selects responds with record-making public commentary. That's not what it is, and it's not constitutionally protected speech and true bombastic journalism. Oh, but there is a critical distinction. Paint Chip is not bound by any sort of professional constraints governing attorney speech. Actually, you are. Actually, you are constrained under those kinds of things. All Annette Cricken had to do was just stop and follow the cease and desist. That's absolutely right. That's all they had to do. See, none of this would have happened if they would have just stopped. They wouldn't have been sued. But you have to understand that instead she went out and tried to, all Randy did was, all that Jeremy did was get a protective order. So they would stop. I mean, he sent them a cease and desist, like, hey, stop. But they didn't. They doubled down, just like they always do. They double down, start stirring up more shit, cause more problems. And then whenever they get called out on it, it's the same way with Travis. I mean, Travis is over there going, I'm done with them. If they're going to start yelling at me, they're going to start harassing, they're going to start misbehaving, I'm going to videotape it and I'm going to make content out of it. That's all. That's all he did. He said, I'm done with it. Felicia just loves the money. Well, she loves their money. She was happy to take every penny of that and not make sure that both Crook, Lynette, and that child did get a damn penny of it. I mean, they'll use it for other stuff that it wasn't intended for, but as far as putting a roof over their head, screw that. And they got more storms rolling in there, don't they? How's that tent doing you, John? That tent feel nice and cozy? Or are you back sleeping in with Lynette again, letting her just, rub her little skeletal body all over you? Oh. The Florida Bars Incorporated may not engage in extrajudicial conduct that creates a substantial actually, I don't think he has so far. Materially prejudicing those proceedings, or more importantly, as an officer of the court, contributing to making them into a mockery. But you're the one that's making them into a mockery, not him. But you're an idiot. When litigation strategy, public strategy begin to overlap, that line matters. But you're very confusing because nothing what you say makes any sense. Of course, that's typical Paint Chip. Well, he does not seek chaos for its own sake. Actually, that would be a lie. He does. And you can tell that he does by everything that he files. He will not pretend this case is something other than what it is. Okay. But you're pretending that it's something else. You're saying it's a lawsuit against a judgment proof. No, actually, you're wrong there. Everybody is that judgment can be fulfilled, and if it's not, well, then they own everything that you think you own, and you won't be able to hide from that for very long. Whenever they start really digging into it, that's going to be pretty bad. Mentally impaired pro se member of the press, but you're not a member of the press. That's the problem. How many times have you been kicked out of the I mean, if you were such a valuable member of the press, Paint Chip, and this would be something to think about. If you were so valuable member of the press, then why can you only get like 3 or 4 people to follow your Substack? And most of those 3 or 4 are you as a sock account. I mean, the only likes you're getting are from yourself. I mean, it's like giving yourself a reach around after sex, and just, okay. not really useful. Now, neither will Paint Chip holding back on going full Larry Flynt in his defense of the First Amendment and the spectacles employed to that end. If this proceeding becomes a media farce, it will not be because Paint Chip manufactured one. Well, it would be because you said that you were going to go full Larry Flynt. So that means that you would be manufacturing this shit. All you had to do was just take the shit down, but they don't listen. They just double down on it. Like, what's he going to do? Sue me. Yeah, I remember Paint Chip was sitting there going, I'm still waiting. Okay. So why are you even filing anything? I mean, that's what always amazes me, that he wants to file shit and say, I didn't file anything. Yeah, I'm going to stir the pot, but I didn't do anything. It's not what it looks over here. It will not be because they manufacture one. It will be because the stupid and his counsel, plaintiff and his counsel selected this forum. I meant to say that because I was reading media farce. I was like, stupid. And counsel selected this form, this defendant, and this theory, knowing exactly what would follow: the foreseeable collateral consequences, public amplification, reputational fallout, transformation of his litigation into content. It flowed directly from those choices. Boy. So you should allow someone to harass you, promote a stalker, make revenge porn of you, and if you don't, then they're just going to amplify and make it even worse. This is whenever you say you've gone full retard and gay at that. If this case becomes a circus, it is because plaintiff brought the tent, counsel lit the stage, and they pulled Luthman into the ring. No, if the case becomes a circus, it's because you made it a circus. Oh, you're welcome. And thank you for the gifted membership. Welcome, new member. Thank you. Thank you.
Welcome to the shit show.
Yes. Every single day.
A new flavor of fuckery.
Congratulations, new members. Oh, it's a beautiful thing.
Monday, bullshit. Tuesday, bullshit. Wednesday,
appreciate you.
More days of increasingly stupid predicament, ignorant, boulder, dash, poppycock, bollocks, and fuckery. We're all over again.
Oh, yes. Let's see what we got here. What we got for us today. Don't see that we have enough people on Rumble to do one. Oh, that's really weird. See, I always thought that thing was up there, but apparently it's not showing up like it is. Oh, there it is. Oh, now it's showing up. See, I wasn't sure if we were going to be able to do this. Oh, I love it when a plan comes together. Because we've got a nice little ad for you, because we did this earlier, and I haven't done one of these in quite some time. But let's see how this one does, because I've got a beautiful one here that might work. Let's see if this thing works. I don't know. Let's give it a try. All right, here we go. We'll give this a run, and we're gonna give this a try here. So let's drop that out of there real quick. Okay, what we have here, you still haven't tried the 1775 coffee, just swallow that stuff down, give it a little guzzle. Now is your shot. The 1775 starter kit dropped only 1,000 units. You're getting the bold, dark roast that hits hard, the smooth medium roast, and the vitality mushroom coffee for clean energy and laser focus with no crash. All single origin, small batch, toxin free and mold free. Plus, you're also getting a gold spoon clip, because who doesn't like a gold spoon? Freedom isn't scooped with plastic. You also get a frother strong enough to stir up your coffee and your mother-in-law's opinions, and a black 1775 tumbler, $170 worth of coffee and gear, yours for $99. This is for the ones who've been watching 1775 blow it up on Rumble, wondering if it's actually worth it. And spoiler, it is. Go to 1775coffee.com/studio. Grab your starter kit before they're gone. Bold beans, clean fuel, and a morning routine that stands for something just like Rumble does. And thank you very much. I think that was good. I hope you like that. Sorry, I've talked out of turn. And all the quality immunity. Qualified immunity should have to have a person insurance. If it is part of the higher bonus, the public taxes go up. Nice. All right, let's get back to this crazy document. We may not get it all done tonight, and I still had something that, all of you new people that have joined in will get to see to cover the lawsuits. Oh, thank you. If this case becomes a circus, blah, blah. See also defendant's prior declaration and motions for vacating default, preserving his special appearance. Well, yeah, no, it's too late. And you keep hollering about the polyflopping, and it's not a word. It's not a word. It's something that you idiots have made up because, well, that's what you do. That's mexual with ringmaster ending. Could be. Ooh, I hope you had a great birthday. Yes, Crystal, I hope you did. You did French. It was yesterday, the 28th, but Shizzy wasn't on last night. To share a gifted member. Oh my gosh, Crystal, I am so sorry. I will have to take up, some problems with that one and get that corrected for you. $5 from Jan Harmony and says, cheers, Shizzy. Thank you for all you do. I appreciate it. Thank you for the $5 super chat. And I appreciate you guys so much. But, if I missed a birthday, I do not like missing birthdays. Yes, yesterday I had a bad headache. It was really bad. It was a weather change or something of that sort. And whenever that happens, you just have to sort of roll with it. So I got your birthday. Here we go.
Joyful time, it's your special day.
Yes, it is.
Gather round, we're here to say happy
birthday.
You're the shining star, let's celebrate you no matter where we are. Tequila and margaritas, party through the night. Cake and candles, the mood is just right. As the candles flicker, make a loving toast to the one we adore the most.
Happy birthday, Crystal. Oh, yeah. I love it. From us rumblers in the ghetto. And thank you very much, Rush. I appreciate you. Thank you, rumblers. It's not really the ghetto. It is just another platform that we enjoy just as much as any other. And we thank you for being here. Most definitely appreciate it. The mods in this community are the best. Yes, we do have some good mods over here, and I appreciate every single one of them. We have a great group of people. The polyflop is commonly used in context of polymer manufacturing, especially referring to a type of a floppant or polymer product designed for applications such as water treatment. Isn't it amazing? Yes. But of course, in this, they're trying to make it a thing. Now, paint chip appears especially like with a plastic helmet, without waiver or of any Rule 12 defenses. But see, you've already failed at that, and he wants a meaningful opportunity to respond to. He never was afforded one, and that count 2 is futile because it doesn't allege privately sexually explicit image within the meaning. Yes, it does, and we already showed that it absolutely falls within that. It seeks clarification, a reconsideration if necessary, and leave to file a proper merits response and a Rule 12 motion if nothing else. Let me throw the book at it. So it doesn't mean anything like it doesn't mean anything like what he says it means. The 78049 means nothing like what he is talking about. And he's very limited on what he says here because we pulled it up. You have to go back and look, but you scroll. If you go back, you can find it. Now, if you're on Rumble, you're going to have a hard time. He's special. All right. Yes, he is. the problem is he's got the issue of, one, identifiable, two, it was sexually explicit under all of the information that they gave, and three, it was public. He shouldn't have done it. That's all I can say. Can you tell me to get up as early as you got an early train? I don't know. When are you getting up? I mean, but documents are not on screen. Well, the documents should be on screen. Not on screen on Rumble? Should be right there. Let's see. I'm pretty sure we've got it. We're stuck on fireworks? Oh, you are. I see that. Let me close that there. There. Now it should be good. There we go. Yeah, my YouTube is freaking out. No, it was just mine. It was just mine acting goofy. For whatever reason, it didn't hide it after it played. It should have taken it down after it played, but it didn't. So, no docs. We got it. You should have them back now. I see what happened. I'll wait. Chat will, of course, catch up here shortly. This chat is always about 10 seconds behind. See, there we go. Yes. And then, of course, he wants to make an argument, which maybe we'll just go over the argument tomorrow, and see what his actual argument is, because I think his argument's going to be bullshit, as it usually is. That he's saying the order, because they shouldn't clarify or reconsider the April 23rd, 2026 order, because their notice of filing was not a merits response. Well, you were told to give a merits response. And if that's how you responded by, doing a bunch of bullshit, guess what? That's what you're going to get back, is a bunch of bullshit. And that's what you got back at you, was just a bunch of garbage. And I hope it makes you feel so much better. Oh, that's all good. Now, put it back out. I wanted to play you some of the retard music, because I think I have it. I'm pretty sure that I do have it. Let me see. So we don't end up with another issue. And I want to make sure that I've got this. So tomorrow, whenever I go over this document yet again and finish this out, we can start out with the argument tomorrow. And that way we don't have to worry about that. So we're looking at page 9 of doc. And also, I do have a locals account, which I totally forgot about. There is an account over on locals that you can check out. And I'm still learning the ropes on it. I might start doing some streams over on the locals thing for members only. Now I'm not sure how all of it works, but I know that it is available. Yeah, I'm not sure how it all works, but what I'll do is I'll get with somebody on the Rumble side and probably talk with them and figure all that stuff out. So that way, if I need to, before I, send you guys over there, I might be able to get you like a free code to come in and all that kind of stuff. I haven't done that yet. So just know that I haven't posted anything on there except for one thing. And that was just saying, we're trying this out. So just bear with me before you go subscribing up to locals. I haven't put anything on there. I haven't posted anything on it except for one thing saying I'm still figuring this out. So whenever I get that figured out, then I'll make sure that it works a little bit better and that I understand everything. And then I can give you like a discount, code for those. Those discount codes are always helpful for that kind of stuff. And let me close all those tabs right there. And I want to see if I can find this song, because it's pretty damn awesome. And it was something I was working on the other day, because it was pretty fun to do. And let me make sure I've got it. It is. Yep, I do have it. I do have it. Is it just the song? Yeah, I just have the song. I was pretty sure I made a video of it. Where did I put the video then? If I didn't put it there. Is this it? Nope, that's not it. That's crazy. I was pretty sure that I had it. But I don't see it. Let's see. So that's not it. No. Oh, that's definitely not it. I don't know where it went to. I know I made a video for it. For some reason, it's not showing up over here. Crazy. I guess I'll just have to play the song for it then. You know, that's going to be the best way to do it, I guess. That'll be the only way that I'm going to be able to do this is I'll just have to play the song for you. And hopefully you get to enjoy it just as much as if I was playing the real thing. Where did I put it? I could have sworn I actually had the thing, but I don't. Is that maybe it? No. Well, I'll be damned. I can't find it now. Did I just imagine that I made this one? Maybe I did. Maybe I just imagined I made it. Yeah, I guess that's what happened. Yeah, no video on this one as far as I can tell. I know I've got the song. But this one is called You're Immortal. It's a new one. It's not the one I was looking for, but it will do. It will do. Let me get this one here, and we'll get that here. Where is it? There it is. Let me share that and add that to stage. And we'll do this and do that. Why is it doing that? There we go. There we go. Now we've got it. Now we've got it right here. It's called You're Immortal. Enjoy, enjoy, enjoy.
Yeah. This is me announcing that I'm back. And announcing that I'm coming.
That's not it. This is it. Stupid me.
You're immortal. Stalker fans. I wanted to say something to all of you, Stalker fans. I am sick and tired of you tormenting me, lying about me, ruining my reputation and trying to cause so much pain and heartache for me for no reason whatsoever. I shared a video of another rescue to show what a wonderful job that he does. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. He's a wonderful person. He has a great rescue and helps thousands of animals. And what happened? You attacked me on that video. You accused me of stealing his content when it said right on the video that I was sharing in support. Yeah. You're evil, you're disgusting, and you're evil, you're immortal, and you should be ashamed of yourselves. Yeah. Rescues should support each other. Rescues should learn from each other. I am so disgusted by you. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. worries, you're not gonna hurt me. You're not gonna hurt my child, and you're not gonna destroy what I started for my little girl because of someone who has stalked me and destroyed my life for 4 years for content on YouTube so they can get rich. To those of you that do care about my rescue, to those of you who do support us, thank you and God bless. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. And by the way, I'm not monetized, so why would I steal his content, idiots? I took down his video, not Facebook, so that you didn't cause any more drama on his channel. I've never caused him any drama at all, ever. I respect what he does with all my heart, as I did the same thing all my life. You're evil, you're disgusting, and you're evil, you're immortal. Stalker fans, you make me sick. And shout out to Wildlife Rehabilitation Outpost. You do amazing work, and you should be very proud of yourself for you and your crew. Thanks for what you do. And shout out to you, evil. You disgusting. You evil. You immortal. Stalker fans, you make me sick.
You guys don't make me sick, though. You guys make me. You make me feel absolutely wonderful. Thanks, Max. I appreciate that. I'm sure it is. That's what they said it was going to be going with any further pleadings or responses. And I'm sure that Judge Hinkle's going to have a good time with that. Yep. Updates. Fed 2 showing everything is going to Hinkle. Yeah, that's the judge already ruled on that and said that it would be going to him. Any pleadings that would be coming in would be going to that. But he also did hand over some of that responsibility to Bolitho, and we'll just see how Hinkle responds. If he does, he may just strike the whole damn pleading. It happens. That's sometimes how these judges go. They don't like having fools disturb the judicial process. But with that, let me see who we've got going on here. And I'm going to do this really quick while I'm here. And go to stop that. And I want to make sure that I've got this set up for you guys so I can send you off. I don't know who's on tonight, but I want to make sure that if there is somebody out there that I can send you guys over to them. So give me just a second and we will see if it works. And I think I can redirect you guys pretty easily. It looks like the man, the myth, the legend, the good old MG Law is streaming. I'm going to send you guys over there, and I've got you covered. We all know neither of the judges will sanction them. At some point they will. And it could be towards the end of the case if they do sanction anybody. And, we'll just have to see how all of that works out. Like I said, it's not my dog, not my fight, but we will find out soon enough. And whenever we do, it's going to be crazy. It's going to be absolutely crazy. I thank you guys for being here tonight. And I will see you guys tomorrow. Yeah, tomorrow. Tomorrow's a new day. I appreciate it. See you guys soon. Peace. Oh, got to do this right. Give you the little outro there, right?
Yeah. Breaking news or whatever. They're on another one. Gang, gang. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5 goons, same deranged obsession. This changes everything. Bro, it's page 47 of emotion they skin while half watching Yellowstone. Gang, gang, squinting at 8-point font like detectives. Zoom so far and the pixels are screaming for mercy. Look at this, timestamp 20, 22, my God. But they're yelling it like they just cracked Watergate. High five. Mike's been muted for 20 minutes, still barking. Circular logic, so a lot of time to seem impressive. Trust the plan, this is massive. Nah, fam, it's boilerplate and it's mid at best. Gang, gang. Self-appointed outrage, swap patting each other like they personally ended corruption. Gang. Dropping bombshell tea that's been sitting in pizza since breakfast. Gang, gang. Moral high ground speed run, they'll flip the script the second it's convenient. Gang. Same PowerPoint presentation, new day, same brain dead narration. Gang, gang. We're not obsessed, we're just passionate. 3-hour living yesterday's hoodie, passion in my ass. Why is he even breathing right now? Says the guy refreshing notifications every 14 seconds. Gang, gang. Playing lawyer on God mode, reading comprehension. Stuck in elementary, confidence in the stratosphere. Case dismissed. It's screaming to the void. Motion still pending, but go off, I guess.
Disagree? Obviously a paid shill. Actually read the filing, deep state plan. Laugh at them, you're clearly compromised too. Exist in the same zip code, suspicious behavior. Notify the group chat.
Gang, 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 gang. Tighter circle, smaller brain. Gang, gang. Echo chamber finally running out of oxygen. Gang, gang. Yeah. Gang, gang, acting the actual judge like it's group chat. Replay all meltdowns, labeled just asking questions. Got warned by the core once, that was a suggestion. Still get it the same screed like it's strictly trash talk. Gang, gang, we're above all this drama. While screenshotting, they on meltdown for content. Preaching peace and love while actively baiting bears. And fake shock when the bear finally bites back. How could this happen? Gang, gang, synchronized tantrum hours. 5 tabs open, all the same screenshot. Different zoom levels, gang, gang. Premature victory lap over legal language, still can't pause. Gang, gang, standing 10 toes on business until tomorrow's filing, send them scrambling again. Gang, gang. Hype the claim to the moon, then ghost the chat when it ages like milk. Gang, gang. Gang, 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 gang. Gang, gang. Refresh, refresh. Gang, gang.